All right, so as to counts 1, 2, 3, 4, 5, 6, 7, 8, and 9, I'm going to adjudicate you guilty. As to count 1, pursuant to law, they sentence you to life in prison without the possibility of parole. As to count 2, attempted murder in the first degree with a firearm, a life felony, I sentence you to 40 years in the Florida Department of Corrections. As to count 3, shooting and throwing deadly missiles, I sentence you to 15 years in the Florida Department of Corrections. As to count 4, I sentence you to 40 years in the Florida Department of Corrections. As to count 5, I sentence you to 40 years in the Florida Department of Corrections. As to count 6, I sentence you to 40 years in the Florida Department of Corrections. As to count 7, I sentence you to 40 years in the Florida Department of Corrections. As to count 8, I sentence you to 15 years in the Florida Department of Corrections. As to count 9, I sentence you to 1,473 days in the Florida Department of Corrections. I will run the sentences in counts 1 through 9 concurrently with each other. I will give you 1,473 days credit. I will run the sentences that I just imposed in 2021 CF 837. And this sentencing is happening all in the same sentencing proceeding. I imposed sentence earlier in the probation cases simply because both counsel advised me there were no additional sentencing arguments. And then I'm imposing sentence now after her victim impact statement, testimony from Mr. Ball's sister in this case, but it nevertheless is occurring in the same proceeding. So I'm going to run the sentence that I just imposed in 2021 CF 837 concurrently with the sentences I imposed in 2017 11673 and 2018 CF 320. So I'm running them at the same time. So that is not to impose additional time on the probation violations. Well, that has the effect of it, presuming that the convictions in the instant case are not disturbed or overturned. $518 in court costs.
The last thing you said, I'm sorry.
I beg your pardon?
The last thing you said for the.
I said that the effect of me running them concurrently is that I'm not giving Mr. Ball additional time on the probation violation because I'm running those sentences concurrently with the sentences imposed in this case, which will have the effect unless these convictions and sentences are overturned of him not serving additional time. So I'm running them concurrently. $518 in court costs plus $50 application fee. I'll convert that to a civil judgment. And I just want to make clear on the record regarding the earlier violation of probation proceedings that the court based its findings at the state board's burden of proof by more than a preponderance of the evidence based on the court's analysis and weighing of the evidence. Because that's, as a judge in violation of probation, I sit as a finder of fact, and so that's based on my independent evaluation of the evidence in the 2021 CF 837 case. All right, so Mr. Ball, you have 30 days to file a notice of appeal from the date I rule on the motion for new trial. If you cannot afford an attorney for the purposes of appeal, I will appoint one for you. If the defense were to file a premature notice of appeal, given that the motion for new trial has been filed, I still will have jurisdiction to rule on that. And as I say, I won't press your time. I'll make sure that I rule on that before next Friday or Friday at the latest, a week from Friday at the latest, I will file that week from today. Okay? All right, so I've imposed the sentences, I'm running them all concurrently with each other, and then, as I say, concurrently with the 2 probation cases. I've given credit for the 1,473 days time served against the defendant's sentences in this case. Credit was granted to the probation cases, part of which will be calculated by the Florida Department of Corrections pursuant to statute. All court cost, fines, fees, surcharges have been reduced to a civil judgment. I've given the defendant his appellate rights, advising him he has 30 days to file a notice of appeal, and that I will appoint counsel for him if he would like me to appoint counsel. Of course, retained counsel is responsible for directions to the clerk and to the court reporter, and ensuring the appeal is perfected. If you don't, if there's no appointed counsel to follow for appeal. Do you agree with that, Ms. Early?
I do. I'm going to follow up with Ms. Jenkins. I discussed with him. He said,
Okay.
oh, good, he's on it.
All right. So I think it's, so as we know, trial counsel is responsible for perfecting the appeal, and then if the defendant is represented later by counsel from the public defender's office, the public defender's office is down in the 7th Circuit, but it's trial counsel's responsibility for withdrawing, if applicable, to ensure that the record on appeal is prepared correctly, and also the appeal is perfected prior to being passed on. Okay?
Yes, Your Honor.
Any other questions? Anything else that you would like to bring up? Nothing, anything from the state?
Nothing from the state.
All right, thank you, everyone. I appreciate everyone during this difficult time, and court is adjourned.
Can you give me just a couple minutes? You're taking a nap right now? Yeah.